chose to do my report on English as a second language, ESL, based on the position that I hold at Huron Middle School. I am a sheltered math teacher where I teach math classes to ESL students at 3 different grade levels. I thought it was interesting to see what the background of this was and to see what rights these students have and what cases have helped develop this as the years have gone on. Just a brief overview, ESL has been in the school districts in the United States since the middle of the 19th century. After World War II, an increased number of foreign language speaking immigrants and schools in the United States started to recognize the importance of foreign language education and the development of new ways to teach students whose primary language was not English. From 1950 to 1980, educators became familiar with methods for teaching non-English speaking students, and state and federal governments began to provide funding for public schools who took an active role in offering ESL classes. Recently, the United States has experienced a renewed need for ESL education due to the rise in the number of non-English speaking immigrants coming to the United States in hopes of living the American dream. There's also been an increase in refugees that are being helped by the United States. Each time a new family enters in the United States, that family's children are placed into our school districts and are given the opportunity to receive a quality education. According to Lutheran Social Services, in 2013, 68,000 refugees entered the United States. In South Dakota, we assisted 389 refugees. In Sioux Falls, and 149 in Sioux Falls. That is less than 1% of the population. However, 35 to 40% of those refugees were students that were placed into our school system. Some of the first times of ESL education was in Florida in 1959 when Fidel Castro overthrew the Cuban government and many Cubans fled from Cuba to Florida. Coral Way Elementary in Miami was one of the first places to have ESL classes. What they did was they took half the class period, or half of the day was taught in Spanish and then the other half was in English. The students were intermixed for things like recess, PE, art, lunch, so they were able to see 2 different cultures at the same time. Another important act that was passed was the Civil Rights Act of 1964. The act did not directly address education, but it did prevent discrimination based on race, color, and national origin in any programs that receive federal government financial aid. This measure is also known as Title VI, and the measure paved the way for schools to offer ESL education while receiving direct federal funding. The school districts were required to give equal access to programs to minority students. Also, in 1966, an organization called Teachers of English to Speakers of Other Languages, or TESOL, was organized. This group provided materials and instructional methods to effectively teach ESL students. Another piece of legislation that was also passed to assist with the ESL education was the Bilingual Educational Act. This came under Title VII of the Elementary and Secondary Act of 1968. Title VII of the Act made the need known for the large number of students in our country with limited English-speaking ability. The Act provided for financial assistance to bilingual programs and also provided funding to train teachers and educational staff more effectively implementing ESL programs. In 1994, Title VII was amended and paired with the Improving America Schools Act to give it increased access to programs to students with limited speaking ability. Then I went on to discuss 3 different cases that I had researched regarding ESL education. The first one, which actually is pretty famous, is Lau versus Nichols, which was in 1974 and involved the San Francisco Unified School District. This case took place, there was 2,856 students of Chinese ancestry at the school, and of those 2,800 students, 1,000 were given additional classes to learn English and 1,800 were not. The students that were not receiving the supplemental education were basically told to sink or swim. These students did file a lawsuit against the school district and sought relief because they felt their educational opportunities were not equal. They alleged violation of the educational rights under Title VI of the Civil Rights Act, which prohibits a discrimination based on color, race, or national origin. These students alleged that it was a violation of their 14th Amendment rights. It's important to note, though, that the students were not asking the school to teach them English. They were asking the school to give them an equal opportunity. The district court did side with the school district as well as the Court of Appeals. They felt that there was no violation of either one of these acts. The students then took this to the U.S. Supreme Court, where the court did rule in favor of the students. The court stated that just by giving them a classroom and the same books and the same teachers was not enough. These students aren't being given another opportunity to learn English. With the overturn of this case, the school districts were able to go forth with ESL education. One way that this does help is that we have sheltered classes here in Huron, which is what I teach. We have those at the middle school and high school level, and it's in all varieties of classes. The students are able to be in a much smaller contained room where they can ask the teacher questions, feeling comfortable with their limited speaking ability, and also to the teacher can instruct at a much slower pace and rate and meet the needs of these students. Many of the classrooms also have hands-on materials to help that maybe a regular classroom might not have. The second case that I researched was Castaneda versus Pickard, and this case took place in Texas. Castaneda was a father of 2 Mexican-American children, and he felt like his children were being discriminated based on the fact that they were Mexican and placed in these ESL classes that they didn't really need. He didn't feel that these classes were benefiting his children and that they were not learning English at the rate that they should have. He felt like there was nothing that was making these teachers or the school districts look at their ability to teach and revamp the curriculum, and he felt the need that there should be something that they have to do every year to prove that their process is good. With the trial, the federal court did rule in favor of the school district, but the Court of Appeals did side with Castaneda and found that the school district was not meeting the requirements of the Equal Opportunity Education Act. As a result, there was a 3-pronged test that helped determine if schools are taking appropriate action. The prongs of the test were all students who do not have English as their primary language must be tested for fluency on a yearly basis. Parents must be given school information for the school in a language that they understand, and the students receive instruction from qualified teachers. You can see that again here in the Huron School District. Our notes that we send home are translated into Karen and Spanish. Our yearly tests that we give them to see what level of ESL they belong in. This case did help because now students go from being an emergent ESL to all sheltered classes to then up into the regular classroom. Without this case, we may not have went over and checked our processes to see if we are really doing the right thing. Another thing too that helps me is I'm constantly checking to see if I'm reaching out and reaching all of my students. I don't always know if everybody understands it because they don't always have the ability to raise their hand and say, I don't understand. So by me constantly checking over myself and checking my processes, I feel like I'm able to reach these students at a different level. Finally, the last school district or case that I looked at was Plyer versus Doe, and this also took place in Texas, where the school district was refusing to offer these kids an education based on the fact that they were illegal immigrants. They were sometimes charging up to $1,000 a semester or a year for the students to come to their school. The district court and the Court of Appeals sided with the school district, but when it went to the Supreme Court, they did side with the students in this case, saying that it is not their fault that they are brought here illegally. They can't control the fact that they are here, and the school districts need to provide them the education that they would provide to anybody else, legal or not. I think this has also been seen in the Huron School District, as we do have many Hispanic students that are here that aren't legal, and we can't not offer them an education. Overall, I do feel like ESL education has improved. Over the years, I feel like with these 3 cases, I've seen how much we really in Huron really are doing for these students. I feel like they are able to get an equal opportunity in their education. I feel that they are given the tools that they need to be successful. Some of them may be able to go to college, some may not, but even if they're not, they're able to become successful and, you know, go out in the working world and learn the things that they need to do to become successful citizens in our country. Thank you.